Good afternoon, everyone. We're going to get started in just a minute. We do have some attendees that are still signing in. We're just going to give it one more minute. Then to be respectful of everyone's time, we will get going.
I'm wearing my St. Patrick's Day post St. Patrick's Day green. So, just that's why I can't use a green screen because just be my head,
Just be a floating head.
just be a floating head.
That's great.
All right. I think now would be a good time to get started. So I want to thank everyone. I'm just going to kick it off and hand it over to my partner, Matt, to get everything started.
Well, good afternoon, everybody, and welcome back. My name is Matthew Wilco. I'm one of the partners of the Legacy Group, and today we're diving into estate planning strategies that matter most for high earners. We like to say this is where financial independence meets long-term legacy. So first item of business would be just some housekeeping as we go to the next slide, Rob. So we have a disclosure here. Before we continue, we want to just make sure that we address this. So this slide is just to remind everyone that we are going to be talking about various financial, tax, and legal concepts and strategies today, but it is not meant to be personal advice for anyone. Everyone's situation, of course, is different, and you want to get personal advice from your own CPA, financial planner, and attorney. We're also fortunate enough today to have Stephen of IX Legal with us today. And as a reminder, IX Legal and the Legacy Group do operate independently of each other. So with that said, let's go ahead and jump into the presentation. So getting to know the Legacy Group, right? At the Legacy Group, our mission is to help clients live a life of greater confidence, choice, and financial freedom. We do this through our service-first philosophy and our three-dimensional planning approach. We integrate financial, tax, and legal perspectives in everything that we do. Now, moving along to the next slide. Right, let's take a step back before we jump into today's presentation and talk about the different segments that we did in this four-part series. So where we started was with capitalization, which we like to say is the engine of financial independence. This is where we all establish control over cash flow, we build reserves, and we create the margin that allows everything else in our financial lives to work. Without capitalization, really nothing downstream is sustainable. We like to say it's the oxygen of the plan. And then that segues well into the next topic we did, which is equity. This is where wealth actually grows. For many, this includes not just capital-based investments, but also items such as RSUs, business ownership, real estate, and other concentrated positions. This is the stage where your money starts working harder for you than you do. But it also introduces a lot more complexity, which is why the next stage, taxes, is so important. With taxes, we focus on reducing lifetime tax drag. The goal, simply put, is to keep more of what we earn. And lastly, this segues into what we're going to talk about today, which is legacy, which is, of course, the natural next step. Once we've built wealth, the question becomes, what happens to it? How efficiently does it transfer to the next generation? And how do we avoid unforced errors that potentially can undo years of good planning? So moving to the next slide. Right, the agenda for today, we just went through the series recap. Simply put, we're going to start with who gets my stuff when something happens. Then we're going to talk about why and how Uncle Sam wants your stuff. And that's going to lead us into strategies to keep what we own. And in closing, we're going to tie all of that together. So introducing my two partners that are going to be leading the charge in today's presentation, right? We have Jeff Velasky, who's the founder and managing partner of the Legacy Group. We have my other partner, Robert Sturgis, who, like myself, is a registered financial planner. And together, our team specializes in really all aspects of financial planning. And as you can see, combined, we have many years of experience. And with that said, I'm going to turn it over to Robert, who's going to be moderating today's presentation.
Thanks, Mac. I have the honor of introducing our guest speaker, Stephen Bonfa, today. Stephen is a partner at IX Legal, and he chairs their estate and tax division. He holds an LLM in taxation, which is the highest level of academic training you can have in tax law. He brings a rare combination of technical expertise and real-world practicality. He is a lifelong New Yorker, deeply rooted in his community. He's built a reputation for helping families protect their assets, resolve complex tax issues, and design plans that truly preserve their legacy. Also, on top of that, Stephen is a passionate educator whose recent book, which I'm holding up here, and you can't really see because of my background, Disinheriting the IRS, became a #1 international bestseller, and for good reason. He has a gift for taking complicated tax and estate concepts and making them understandable and actionable. We're thrilled to have him with us today to share insights that directly impact high-earning families and business owners. Stephen, thank you so much for joining us. I'm going to hand it over to you to let everyone know why it is that they need an estate plan.
Thank you very much for that generous introduction. I'm a lifelong Brooklynite, and now I'm in Long Island, so I certainly appreciate that introduction. I grew up focused on helping people in this area, so I try to treat my clients like family and my parents. Getting to the topic, everyone needs an estate plan. I get people to say, I don't have a lot of money, or I have everything already, situated where I don't need one. But it's more than just that. A will and an estate plan, you know, helps you plan for unforeseen circumstances. Is there a death? Is there a personal injury, wrongful death action? Did someone die? Is there marriage? There are people in favor, they're not in favor anymore. So your estate plan will help you do that. Whether you have a little bit of money or a lot of bit of money. I've seen a lot of hotly contested things with just a small estate. It's all about deserves. Another reason is estate tax, and we'll get into more into this. This is the whole reason for this. Without an estate plan, there is no estate tax planning, and it's all estate tax. If you have minors or someone who has special needs, without an estate plan, you can't help those vulnerable beneficiaries. So you want to be in control and not Governor Hochul. So you want to make sure that what you want happens. This is whether it's who gets your watch, or how do I handle an IRA that has $3 million in it. So it's all about control. The other thing that people sometimes forget is that sometimes in your family tree, there's an apple that has a worm. And if they're entitled to be an heir and you don't want them to be an heir, if you don't have an estate plan, guess what? Your phantom Mercedes convertible is now going to go to someone who you don't like. So you want to be able to do that for who you like and who you don't like. So, and also there is no asset protection. Nothing is protected if you don't have a plan. So those are the reasons why we really need to have some type of estate plan in place.
Stephen had mentioned, planning for estate taxes, and Richard Miller, who was a very well-known financial planner, had this wonderful saying that inheritance taxes are so high that the happiest mourner at a rich man's funeral is usually Uncle Sam. To further illustrate that, Stephen, I'm going to hand it over to you. I'm sure most people here are going to be familiar with the next gentleman we're going to discuss, but we're just going to talk about showing what the true cost to not having a plan could mean to you and your family.
Yeah, James Gandolfini and his estate is a case study on what not to do, essentially in an estate plan, or basically the lack of one. He had a 17-page will, that he signed 7 months before he passed away. And you hear a lot from celebrities who have the means and the ability to employ people like me, and everyone here, all these other panelists, Matthew, Jeff, and Rob, to get a plan together and essentially do the right thing. And he had a simple 17-page will. He left all his assets essentially to his 21-year-old daughter. 80% of his estate was reachable by taxes. He paid somewhere around $30 million unnecessarily to Uncle Sam. So his family could have collected $70 million, but they only got 30 million, essentially 40% of that estate plan. So it's not just for people of medium wealth or a lot of wealth. It's having a plan is important. Otherwise, the government's not going to care. They're just going to say, "Hey, give me what you got," and they're going to go right into your pockets and they're going to take it from your family. The only way to take care of that is really to plan.
What we're going to do now, we're going to again hand it back over to Stephen to discuss ways of planning that can make sure that you and your families avoid the same fate as Tony Soprano.
So whenever I have someone come into my office and we start talking about estate planning, I ask some basic questions. We joke around, but there are three basic buckets, what I call buckets of planning, when it comes to setting up your estate. One is who gets your stuff. Who do you want to get your stuff? Is it just everything to my wife and then to my children? Is there some specific gifts that you want to give? Is there some charity? Are you charitable inclined? And sometimes if you're not charitable inclined, sometimes it's good to become charitable inclined to reduce, to reduce things. So it's really important to get on the onset an idea of what is the scope and nature of the assets that you have and who do you want them to go to? And as I alluded to a little bit before, who you don't want it to go to. These are all important things to get an idea. Who's important to you? Who's capable of managing your estate? Things of that nature you have to get into your mind. The second thing is Uncle Sam who wants your stuff. Okay. This is tongue in cheek, but it's essentially without a plan. I tell clients, Uncle Sam and Governor Hochul have a plan. You need to make a better one. And this is all about taxes, estate taxes, and more taxes. How close are you to the different thresholds, whether it's a federal threshold or a New York State threshold, or whatever state you're in? Every state has its own thresholds, and some don't. Like New York's is 7.9 million. New Jersey is, if you give it to your kids, it's zero inheritance tax. But if you give it to your brother, you have an inheritance tax. So we have to understand the nature and scope of your assets and try to make a plan to make sure we minimize your exposure. And last is how to keep your stuff. This is all about asset protection. Is there a Medicaid issues or planning that you want to do to make sure that if you need assistance in the future, that you get to preserve some of your assets in that capacity? How do we protect assets in that capacity, whether it's from healthcare or from taxes, etc. So this is what I need to get an understanding of from my clients when they come in. So essentially we see, if moving on, starting with, who gets your stuff. Every estate plan, okay, can take care of essentially what you want, okay? There are three basic types of instruments that we do when we employ. One everybody knows is a last will and testament. One we know as a revocable living trust, and then there's an irrevocable trust. Each one of these have pros and cons as to whether or not it's a good thing for you or not. So the advantages we find in the last will is it's flexible. It can be amended. We can do estate tax planning. We can distribute your property any way you want it to go. And what clients like about the last will, it's usually the least expensive to set up in the front end. Okay. The disadvantages of a last will is you have to go through a probate proceeding. So that means your executor, someone who you stay, if you have a will, has to get your original will, go to court, file it, pay the filing fees. Every state has its own. And then in New York especially, you have a delay. The delay is 7 months to distribute your assets. I've seen simple, uncontested wills and probate proceedings last 18 to 24 months before you can distribute the estate. There is no asset protection in the last will. So if you're thinking about, sheltering a house or money, you don't get that through a will. So also, most states require notice. So everyone who's a natural heir who would collect if you had no will has to get notice. It's a way to that person to come in, and it incentivizes someone who is a natural heir to do a contest. And nobody wins in a will contest except for me. So we want you to win. I want to win too, but I'd rather you win a little bit more. So there are some issues with the last will that has advantages and has disadvantages. The next level, I guess, would be a revocable trust. A revocable trust has all the advantages of a will, and it adds a fast distribution. And it's a fast distribution because you don't have to go to court, go through a filing, pay your filing fee, and then wait to get appointed, and then wait to do an accounting and do all that stuff. It's a fast distribution. Technically, if you have items in your revocable trust, the day after someone passes away, you can have a distribution. Like practically, it takes a little bit longer, but you can actually go through it very quickly. 30, 60, 90 days is really, really all you need. You retain complete control of all of your assets. And unlike a will, there is no notice provision to anyone who's not who you list in your trust. So there's no need to get someone to sign a consent or have a hearing to see if they want to object to what you have. If they're not in it, you don't even have to tell them you're dead. Okay? That people like that aspect of the revocable trust. Some disadvantages are it's more expensive to put together. It still doesn't give you asset protection. There's typically some year-to-year administrative costs, especially if someone else is your trustee. And there's also always a loss of a basis adjustment. So what that means, let's take a house. If you bought a house for $100,000 and you sell it for $1 million, you have a capital gain exposure. Okay, so when you pass away and get things by inheritance, that that cost basis readjusts to the fair market value at the time of your death. We have to plead and write things carefully in revocable trust, and especially in irrevocable trust, which I'll get to in a moment, to make sure you do not lose that basis adjustment. This is one of the cornerstones of all estate tax planning, is that getting and preserving that basis adjustment. Finally, there's an irrevocable trust. Irrevocable trust wears many hats. Unlike a revocable trust, an irrevocable trust is usually made for a specific reason. And in a revocable trust, we say put everything inside. Make all of your assets not subject to have to go through a probate proceeding. So it is really something that is all-inclusive. With an irrevocable trust, that's a laser focus, okay? It's a carpet bomb versus a guided missile, all right? We have to really focus on. There's irrevocable trusts that deal with Medicaid planning. There are irrevocable trusts that deal with life insurance. A lot of people do irrevocable trusts to deal with Medicaid, long-term Medicaid planning. You have most of the advantages of a revocable trust in asset protection, estate tax reduction. You have control over your distributions and where it goes. You can do income tax planning. And the benefit in a Medicaid trust is it protects whatever you put inside for Medicaid. After the look back period, Medicaid can't put a lien on, or it doesn't factor into your calculations. With all revocable trusts, okay, there are some disadvantages. The biggest one that I have with people is loss of control. You are not the trustee. Someone else is the trustee. So if you need something, you want something, you have to ask that person, can you do this? When it comes to a Medicaid trust, assets cannot be used by you, the grantor. So cannot be used for your benefit. So if you have $100,000 in the Medicaid trust and you want to buy yourself a car, you cannot go to the grantor and say, hey, give me $20,000 or give me some money so I can go to the Disney vacation. There are gift tax implications. You may have to file a gift tax return depending on your situation. And you have a high loss of step up in basis unless you specifically have some magic words that are contained into your irrevocable trust. You're going to lose your step up in basis. And there's very limited flexibility. There are some things that we can do, which is beyond the scope of our conversation today, to try to return some flexibility and control. But you have to say it's like Moses and the tablets. Once it's carved into stone, it's very difficult to change. So those are the three essential instruments.
So possibly one of my favorite quotes. I probably saw this when I was in high school, and little did I know that I'd be getting to say this on almost on a daily basis in my for work. Benjamin Franklin said, nothing is certain except death and taxes. And he said that back in, I believe it was 1789, over 230 years ago. What did he see then that, is obviously what we're experiencing now? The tax laws were punitive then and they're punitive today, right? And they're going to be punitive tomorrow. When most people hear that, they think, oh, well, there's nothing I can do about it, right? Well, that's not actually true, especially when it comes to taxes. Death is unavoidable and inevitable, right? We're all going to die at one point. But how your wealth is taxed, transferred, and ultimately distributed, that is highly controllable. And that is what we're hoping to change today, at least your perspective on it. Stop accepting taxes and really looking at it from a, how do we engineer an outcome? Because the reality is the government doesn't get to decide how much you pay. Stephen said this earlier, your planning or lack of it is what decides what is paid. So instead of treating it as a certainty that you can influence, we start treating it as a problem that we can solve strategically. So we previously, so Stephen spoke about bucket one. Bucket two is very simple for me, right? Bucket two is is Uncle Sam wants your stuff. And what that really means is how much of your wealth is going to leak out of taxes before it reaches the people and the causes you care about. This is where estate planning becomes part tax strategy, part legacy strategy, and part risk management. When we say Uncle Sam wants your stuff, we're really talking about three claimants, right? It's your heirs, the IRS, which actually spells out the word theirs. If you see that, the IRS spells out theirs because they truly believe it's their money. And it really, unless you do something about it, and what we're going to talk about, right, they're going to get a bigger chunk that they really deserve. And then there's charity. Charity is always an option for people. It's one that often gets overlooked because people feel that by giving to charity, I'm not giving it to my kids, but they often fail to see the win-win in it, usually creating some tax benefits that can have a significant impact in the overall plan and design. So bucket two is not about fear. Okay, bucket two is really about leverage, and high earners often assume that estate planning is only about estate tax exposure, but they're all obviously wrong because the bigger issue, the way we see it, is that income tax exposure on retirement accounts, accelerated taxation under the Secure Act, and often a lot of missed opportunities when not using trust and charitable tools to reduce the tax bite. Now, this is where what we're going to talk about next is where a credit shelter trust and an irrevocable life insurance trust, a SLAT, a spousal life and assets trust, how they come into play, because they help you control how assets pass. They help you reduce taxes over multiple generations and protect wealth from being eroded unnecessarily. And if we layer in charitable planning, we can often direct dollars that would have otherwise gone to pay an IRS tax bill into causes and to the people that you care about most, right? So bucket two is simple. Minimize the tax exposure or what's going to go to Uncle Sam and maximize what goes to the people and the causes that matter the most to you. This bucket is where thoughtful planning can create a lasting legacy.
Thank you for that. And I think you're exactly right. It's I tell clients, no plan is a plan, it's the worst one. So it's really it's all about getting ahead. We can make plans up until we can't when you pass away. So, if you were throwing around quotes, I see your quote, I'm gonna raise you one, which is something by Archbishop Cushing, who said, it wasn't raining when Noah built the ark. Okay, so once it starts to rain, it's too late. So we need to plan ahead. With tax planning, especially, you need to plan ahead and get things, in the scope. So, in order to talk about estate tax, you have to know what the thresholds are, and the one big beautiful bill made permanent. If you have anything under $15 million as a single person, it does not get a federal estate tax. Okay, if you for inheritance, if you're over 15 million, you're taxed at 40%. That's on the overage. So if you have $16 million, you're going to pay 40% off 1 million. Every state has its own rules, as I alluded to before. New York is pretty brutal. If you're over a certain amount, it taxes you at day one. The other thing that people always talk about is the yearly annual gift, which is the next slide. And in 2026, it's $19,000. So you can give $19,000 away to as many people as you want, including your favorite estate tax attorney. And if you're married, you can give double that amount. So one of the ways that if we do some planning and we see you're at or close to any of these thresholds, we might do annual gift planning. You and if you're married, you and your spouse, you can give, was it 38 million to 38,000 to your son, your daughter-in-law, your grandchild. You can and without having to file a gift tax return. So it's really every year it changes. And typically only goes up in recent years anyway. But you can do that and pretty easily per year, and we do some good plans with that as well.
If you haven't picked up on it yet, we love quotes. This is one of my favorite. Warren Buffett said that government can't deliver a free lunch to the country as a whole. It can, however, determine who has to pay for lunch. And what we're going to go through now, and what Steven's going to help you with, is showing you different strategies to make sure that when it's time for that credit card roulette, when the bill comes, your credit card isn't getting picked.
Absolutely. So to start off the conversation, 90% of the people that come into the office, they have what we call an I love you estate plan, which means when I pass away, everything goes to my spouse. And then when my spouse passes away, everything goes to my children or beneficiaries or whomever. That is a simple plan of distribution. Sometimes, the straight line is not the best way to go. It may be the most direct, but when it comes to taxation, it may not be. And there's some simple things that we can do to alleviate that. And one of the strategies we employ is what we call a credit shelter trust. So keep on this first slide for a second.
Cool.
So without a credit shelter trust, let's say we have $8 million or 16, well, it's $8 million in New York anyway, or $16 million in the Fed. If I give 100% to my spouse, okay, there is no taxable event when I pass away. We have what we call an unlimited marital deduction. So if Jeff Bezos wants to give all of his money to his wife, there is no federal estate tax, okay, because it's an unlimited marital deduction. When the second spouse passes and they pass that $15 million, okay, then that spouse will then have an estate tax consequence. The first 15 million passes tax-free, and then that $1 million on the overage passes, at a tax at 40%, and you have a tax bill at the death of the second spouse. So as to give everyone a framework, a credit shelter trust works its magic at the death of the second spouse. Okay, so next slide, please. So in the same instance, if when spouse A passes away, they create a credit shelter trust. It's known by a couple of names: a disclaimer trust, an AB trust, a family AB trust. There's a bunch of names for it, but I like calling it a credit shelter trust, and a lot of people recognize what that is. So when the first spouse dies, they put up to the exclusion amount into the credit shelter trust, whether it's cash, whether it's property, whether it's stock. And now it lives into this credit shelter trust. The overage passes to the surviving spouse. So a credit shelter trust gets 15 million, and the surviving spouse gets $1 million outright. Okay, there is no taxable event. It's passing under the threshold amount to the trust, and is passing an unlimited marital deduction to the surviving spouse. That credit shelter trust now lives with the spouse. The spouse is the beneficiary. They can get income. They can have withdrawals from that account. You just have to know that whatever comes out of it at that time is taxed to the spouse at ordinary income, but it lives and appreciates in that credit shelter trust. And like I said, the magic happens at the death of the second spouse. So now the second spouse dies and the credit shelter trust ends. Everything in the credit shelter trust empties to the beneficiaries, and the spouse, that $1 million that the spouse had, empties into the beneficiaries. You've just wiped away $400,000 of estate tax from the Fed. It's tremendously more, especially in New York, okay, where it doesn't believe in certain things, okay, but in New York, you also have that protection, okay? So instead of paying $400,000 at the death of the second spouse, you pay zero. That is how the credit shelter works. It's even more when you factor in your state taxes, because that can be lower thresholds than the Fed, but it's a really great way to do that, while also giving the spouse access and the ability to take advantage of the credit shelter trust. What we find out, one of the things we do is we have to get a comprehensive idea of what your assets are. And sometimes when we look at people's assets, we see it's life insurance that may be pushing them off. So no offense to any life insurance brokers on the call or in the room. Life insurance is sold as a tax-free gift or award to the people who receive the proceeds at your passing. This is true. The person who received the gift does not have to pay any taxes. However, Uncle Sam says, and New York State says, and most states say, someone's making money somewhere. I deserve a piece of the action. And it becomes, while the person who receives the gift gets it tax-free, it is part of your taxable estate. So if I have someone and they have $3 million of taxes and they're at a 12 or a $13 million asset range, which people think is a lot, but really isn't. Okay, it's easy to get there with some homes and businesses and investments. But we see that what's pushing you at, near, close, or over the threshold amount is a life insurance trust. We have to do something to try to get that life insurance out. And an irrevocable life insurance trust, or an ILIT is what we call it, is the way to go. So what you create an ILIT, it's after 3 years. There's some rules. After 3 years, you have to survive the ILIT for it to be removed. There's some funding issues that we have to work through. There's some administrative issues. We have to issue one of my favorite things called a crummy letter. There was some guy named Crummy, and that's how it got its name. I always envision him as being blue with hair and being the Cookie Monster, but we have to have crummy letters. So there is some stuff you have to do, and you have to outlive it by 3 years. But it's a great way of getting this out of your taxable estate. So this is something that we can do. If this is what it is, if you have these life insurances, if you have a tremendous number or big numbers, or even small numbers that are pushing you over.
Yeah, Stephen, I'd love to just chime in a little bit on this, because it's often something that we talk about it and with our clients, and you said it just right? If someone has a net worth of, $10, $12 billion, and all of a sudden a big policy pops in, I always say to them that, the reason you buy life insurance is not the reason you're going to need it later in the future. So a lot of times when people buy life insurance is because they have a young family, they have debt, replacement of income. But as that wealth, grows, right? And that's what happens for a lot of people, right? They find themselves in a situation where, hey, we no longer need the insurance to replace our income, but rather, cover a tax bill or create liquidity, because in some cases you have the states that are highly illiquid, and that a life insurance, although it's not a great idea for high net worth individuals to own it, an irrevocable life insurance trust is an extremely powerful tool, right? To still keep the benefit, the tax benefit of the insurance in a more tax efficient way. So yeah, that's a lot of good points there.
Thank you. The next is something we call a spousal lifetime asset access trust, or a SLAT. And the SLATs, one second. We do this again on cases where it's important. So when we speak to clients, okay, we have to get an idea of what they have and what they don't have, and what is pushing them over the threshold or potentially the threshold. So a SLAT is an irrevocable trust that's created by one spouse for the benefit of the other spouse. Okay, and you can also add, descendants or other people as what we call remainder beneficiary. So the donor, the first spouse, the idea is to remove those assets and future appreciation from the taxable from the person's taxable estate. SLATs are irrevocable, so we have to measure things, very carefully, and it cannot be reclaimed. The assets cannot come back to the donor, the person who created and transferred the items. It has to stay within there. So a SLAT reduces estate taxes by removing the assets and future appreciation from the taxable estate. So remember, that's why we have to look at what you have and see where it puts you. Okay, it provides indirect access to the wealth, your assets that you put into SLAT, because the beneficiary spouse can receive distributions that may benefit them as a unit, as opposed to having other assets that remain outside of the donor estate. So it's protecting some assets. Okay, it does provide some creditor protection, and also if there's any family disputes or lawsuits, it's a way of handling that as well. It's a really good way to facilitate long-term multi-generational planning, and there's something that's called a generation skipping transfer tax, generation skipping tax, that we can potentially have it removed from there. So if I give the simple for a GS called GST, the simple way to explain it is if I give a gift to my children, the government has a ability and an opportunity to tax that estate. And then when my children die and pass that same money to their children, the government has a second opportunity to do that, okay, to tax that on as an estate basis. So if instead of giving it to my children, I give it to my grandchildren, I'm skipping a generation and an ability for the government to tax you a second time. So the government doesn't like that. Remember, Uncle Sam wants a piece of the action. So depending on how much assets you have, or depending on whether the GST comes into doing it. We also really have to think about, your liquidity, and we have to think about what happens if there's a divorce, okay? Because SLAT is what it is. So we have to think about those factors as well. The ideal candidates we find for SLATs are individuals or couples with significant assets who want to reduce or eliminate their transfer taxes or estate taxes, families who want asset protection for their heirs, couples in stable marriages who are comfortable with the loss of direct assets, things of that nature. People who really want to have multi-generational planning. So this is what that SLATs are for. This is what we use them for. But again, it's one thing you'll see, and I say to my clients, there's no cookie cutter. Any attorney you go to, and they already have the form made, and they just say, sign here. There is no cookie cutter plan because everyone's situation is different. And what might work for you might not work for someone else. So SLAT is a really good, tool in your toolbox. The other thing moving along is charitable planning. And sometimes people are like, why would I want to give anything to charity? I have my family to do, and I get that all the time. But if we can leverage charity where you don't have to spend $400,000 in taxes, at the end of the day, that's $400,000 more that you can give to your family. And there are a bunch of different types of charities charitable planning instruments that we can use to try to do that. And it really depends on what you have, what you want to do. There's things that what we call a charitable remainder trust. There's charitable leads trusts. There's donor advised funds. These are all ways to reduce it. Each has their own positives and negatives. And there's something that I like to do as well. It's called private foundation planning. So if you have funds and you want to be able to establish a legacy for you. I've had clients who don't have children. They don't like their family, so they want to do a private foundation. It's a really good way of creating a legacy for you, as well as reducing your exposure to estate tax. Again, it all depends on what you have. Do you have cash? Do you have property to determine which charitable vehicle is appropriate for that?
Thank you so much, Stephen. I think you did a great job discussing bucket two, estate taxes, and that focused predominantly on what happens after you die. It's about minimizing the tax burden on your estate and maximizing what you leave to your heirs and your loved ones. What we're going to shift to now is bucket three, and this is about planning you can do while you're still alive. It's proactive, it's protective, it's about shielding your assets from lawsuits, creditors, and unintended consequences, especially if you're a professional with liability exposure or business owner with side ventures. This is where entity structure matters, where titling matters, where trusts aren't just for tax planning, they're for protecting what you've built. And for families with blended dynamics or special needs beneficiaries, this bucket ensures that your planning doesn't accidentally disqualify someone from benefits or leave them vulnerable. In short, bucket three is about keeping what's yours while you're here to enjoy it.
Yes, that's you're exactly right. When we deal with estate taxes, we're thinking about the day after you pass, and when we deal with asset protection and bucket three, we're dealing about what do you do now while you're alive. One of the things that we have to consider when people come in and they have IRAs is the Secure Act. I advise clients that the worst possible tax position is to when you inherit an IRA is to take the lump sum distribution. Uh, what happens is you get a letter in the mail from the IRA that says, "Hey, I have $1 million for you. Sign this piece of paper. We'll withhold 20% for taxes, and you get $800,000 of money check in your pocket." And then April comes around and surprise, now you have $1 million of income, and now you're two or three tax brackets up from where you were before. And I've seen IRA people who take lump sum IRA distributions lose 35 to 40% of that IRA. You worked hard for it. You had your potentially your employer contributing, and now suddenly, 35% of it is gone. I had a client come in with exactly this information. They came in, the parent passed away. I was getting the probate. They were talking to me about that, and they said, "Hey, I got this IRA. What'd you do with it? Oh, I have a lump sum." I was like, oh boy, that's terrible. They had the check in their hand. They were actually going to see me and then go to the bank and deposit it. And we were able to head that off. We contacted the custodian, and we were able to stop that check. So instead of getting hit with 35% of loss of that IRA, we saved that person only because they came to me and they were on the way to the bank, which was an amazing coincidence and good for that client. Your best position is to roll the IRA into what we call an inherited IRA instead of taking the lump sum. There are rules. Again, Uncle Sam wants money, okay, and it's very jealous when someone is saving money, especially from estate taxes. So there are some rules. By rolling it into an IRA, you extend the ability to be paid out over the course of time. Depending on your relationship, it could be for the lifetime of the person who's the beneficiary, but typically it's 10 years. So instead of getting that $1 million all at once and you get that $1 million hit in April, you're spreading that $1 million over the course of 10 years, which hopefully will have a much less impact on your income tax bracket, and you don't have to lose all that money, if at all. So depending on how we plan correctly. So that's what the Secure Act says. You don't want to get that lump sum. When it comes to IRAs, we can deal with this in your estate plan as well, either through whatever instrument we use, or there's something called an inherited IRA trust, where we can force the stretch. And if I have clients that come in and I do an inherited IRA while they're alive, and that's because, well, my son is an artist, doesn't really know anything about money, and we want to make sure that person picks the stretch and does not just take that money, that $1 million dangling. So that's what the Secure Act. There are rules with regard to it. Obviously, I'm giving a simplistic outline, but there's something you have to consider. All conversations end with a conversation about long-term care Medicaid planning. Okay. So Medicaid planning is long-term care Medicaid. It's not Medicaid or Medicare or or health insurance. So you can get Medicare as a health insurance, Medicaid as a health insurance. That'll pay for your hospital bill. That'll pay for your doctor's prescription, etc. That's not what this is. So if something happens, you go to the hospital. Hospitals offer emergencies. And then when the emergency is over, they kick you out. They either send you home or send you to a rehab. And most insurances will pay for about 180 days. After 180 days, it's considered permanent, obviously depending on your health insurance. There's only three ways to pay for permanent care. Okay. That is that you pay out of pocket, you have long-term care insurance, or you ask Uncle Sam to pay. And what long-term Medicaid planning is a federal program that's administered by your state. So every state has its own rules. So you need to look at what your state rules are with regard to thresholds and what qualifies you, etc. But if you need help, whether it's an aide to come to the house, or you need to, if it's severe enough, if you need to go into a long-term care facility, there are things, thresholds have to admit they're not designed for people with money. They're designed for people at the indigent level, and they define what it is to be an indigent. And there's a medical eligibility and a non-medical. So how do we get to preserve your assets? I tell clients Medicaid planning, long-term care Medicaid planning does not benefit you in any way. It's for the benefit of your heirs. Okay. It's an insurance of inheritance. Okay. You will only have restrictions and your children only have the benefits. So when I'm Italian, when I have the Italian people come in with their kids, I put the guilt on them and I say, hey, if it costs you $8,000 to do a Medicaid plan, get together with your three kids. If everyone puts in $100 a month, you're going to get more than halfway there. It's worth it. It's worth it to do a plan to protect my $1.2 million house. So we can do things to protect it. We can do what we call Medicaid asset protection trusts. They have rules with regard to what that is. It's a loss of flexibility, if you can remember from that other slide, but it does give you protection. There are other things that we can do to do it, but long-term care Medicaid is a big part of it to protect your assets from that situation. Your first line of defense, if you can, is long-term care insurance. And I'm sure there's some really good people here that can help you with that. The other thing when we talk about this is protecting vulnerable beneficiaries. So if I do not have an estate plan, you cannot protect vulnerable beneficiaries. So if you have someone with special needs, if they're on government assistance, if they get an inheritance, it can knock them off. So if they're getting Social Security disability or things of that nature, those are need-based, you can knock them off. So by doing simple things like establishing a supplemental needs trust where they can collect your inheritance and then also use that money further. And then the benefit of the plan is the government cannot seek reimbursement from a supplemental needs trust after that person passes away. It's different than a special needs trust. Okay. I'm not really, I don't want to deep dive into the distinctions, but when you do your plan, at the end of the day, even if the government gave $1 million of assistance, when that person passes away, it's fully inheritable by your heirs or their heirs, whoever you want, as opposed to having the government seek reimbursement. And I always hate it when the government reaches into my pocket, and I hate it just as much when they reach into yours. So that's how we handle protecting these more. Also, like James Gandolfini, the age of majority in most states is 18. I know how I was at 18. And if I got $1 million or the house, I don't know how long I would have. I was a nerd, but I would be a nerd with $1 million house. So I don't know how that would have went. Maybe I wouldn't have been a nerd for about a year. But aside from that, it's you can pick the age of majority. If you don't, your 18-year-old is going to get your house, going to get your stocks, going to get your cash, it's going to get your jewelry, it's going to get your car. Maybe that's not really what you want. And finally, we have families who unfortunately have people who suffer from addiction, and you don't want to give someone who is suffering from drug or alcohol addiction $1 million in cash. I tell them I want to be invited to that party because that's going to be fire trucks and it's going to be the police, and it's going to be a wild bash. But you don't want your legacy for that person. You're only injuring that person more by giving them unfettered use of and control of your legacy that you worked hard for. And the only way to prepare for that is through advanced planning.
So prepaying taxes. So how do we get there? Well, you've met with your advisors, you've met with Stephen, hopefully you've met with us, we've done planning, we've given you recommendations on how to you do everything you can. But then at the end of the day, for some reason, we can't plan around it all, and we know there are going to be taxes. So let me give you a different way about thinking about the word tax, right? Especially for those of you who already know you have a problem. If you know the tax is coming, the question is no longer how do I avoid it? It becomes how do I pay it in the most efficient way? One of the most effective ways to do so is by prepaying taxes while using life insurance inside of an irrevocable life insurance trust, which Stephen spoke about a little while ago. So the concept is here. It's really simple, and you'll see it in a minute when I describe it to you. So earlier, we also spoke about your annual exclusions. And an annual exclusion is a credit that everybody has, right? It's a use it or lose it. Every year, we have the ability, for instance, this year, I have the ability to give $19,000. My wife does too, but collectively $38,000. And then you can multiply that by how many kids you have, and that's an amount that you can gift into an irrevocable trust. Specifically, this one, for this example, it's an irrevocable life insurance trust, right? So essentially, you make the gift to the trust, and the trust just buys life insurance on the life of the insured, or in the best case scenario, if you're married, you're buying a second to die policy because it's the most cost-effective way to do so. Just to give you a quick example, we did this for a 60-year-old couple a few years ago that after planning, they still had about, an $8 million tax liability. And that was only going to grow because they had an excess in wealth, and we had already removed everything, utilized all of their exemptions. So what ended up happening is saying, look, we need to start a gifting strategy, right? And they were okay with gifting strategies because they had more than they were going to need. And ultimately, they had 3 kids, and collectively they were able to give $38,000 times 3, upwards of $100,000. That $110,000 or $15,000 gift created a $9 million death benefit upon the second death, right? But if you think about it, they were only in their 60s, even if they lived for another 30 years, you're talking about a $3 million tax or premium payment, right? That covered the entire $9 million tax. So the point is here is that the life insurance creates a tax-free death benefit outside of your estate. So what you're really doing is you're taking dollars today that would have otherwise gone to taxes, and you're repositioning them into a tax-free pool of capital for your family. You're doing, if you do nothing, the IRS is going to take it. The family I described already knew they had a problem coming, which is why they chose to basically lock in a smaller portion of what would have gone to taxes to a gift, which was then bought life insurance to cover the entire amount. That's what I call it, a tax arbitrage, right? Using discounted dollars to offset a potentially much larger liability in the future. And for families with an estate tax, this becomes very powerful. It creates liquidity, it protects assets from forced sales, and it also ensures that the people who are inheriting your money, they're not inheriting a problem, they're inheriting a solution. Bottom line, if a tax is unavoidable, the goal is to pay in your terms, and if you can, at a discount.
Steve, I know there's a lot on this slide, but to be respectful of time, could you quickly just go over some benefits and disadvantages of a life estate for our members here?
Yes, a life estate is a very quick and easy way to get some asset protection and do that. There's really some great advantages. You can't be evicted, you can't be charged rent. So what that means is, let's say I put my children as title owners of my house because I want them to get it. And that's what we call the remainderment. And then I have a life estate. But I have people come in and say, I don't want my kids to evict me, or I don't want to be charged rent, or I'm afraid that when they pass away, their spouse is going to not honor our agreement. You really want to do a life estate, in a situation like this. You have essentially some incompleted gift. You get all the property tax benefits. It does give you an exemption from Medicaid after the look back period, and if your children pay they get those deductions, and you get the capital gains increases. So people say, hey, that's a great way without having to do a Medicaid trust to protect the house. But as your children can't sell or mortgage the house without your permission, you can't do it without them. So there's a loss of control. Your children now have a asset, so creditors can reach it if they're filing for bankruptcy, if they're filing for financial aid for their children, or if they're just having a bad time financially, creditors can reach it. There is no capital gain protection if it's sold while you're alive, and if it's sold after the property is exempt, that look back period is removed. So I've just lost 6 years in planning. The other thing I say as well, if that child passes away and now there's a spouse or there's a divorce or there's a grandchild, now you have partners in the house, or if the child becomes estranged, there could be a problem if I want to sell and they don't want to sell, and or things of that nature. So life estates are really good. It's a little bit of a hedge, but again, there's any attorney that comes in and says this is the way to do it. I do this for everybody is not the right attorney to have. There's no cookie cutter when it comes to these issues.
Thank you so much, Stephen.
All right, folks. So Matt Wilco again here. We want to thank you for all of your participation over the last hour. My partner Rob mentioned that we really like quotes here at the Legacy Group. So, of course, as we're coming to a close, we wanted to end with our favorite quote as it pertains to estate planning, which is the best time to plant a tree was 20 years ago. The second best time is today. So estate planning is a topic that is very easy to kick the can down the road. Getting your planning done as soon as possible is really paramount. I want to direct everyone to the 2 QR codes that you see on the screen. At the first one with the Legacy Group, if you scan that with your cell phone, that's going to directly take you to our calendar to schedule a consultation, a no-cost consultation with either myself, my partner Rob, or my partner Jeff. And directly below that, you'll see a second QR code. And if you scan that, that'll directly take you to Stephen's calendar to schedule a consultation with him. We did receive a few questions throughout the course of the Zoom today. We are running a little short on time, so I'm gonna pose one to our panel. And the first question that we received was, how do we deal with our children's spouses and estate plan? So Stephen, if you want to maybe take 1 minute to kind of give an overview of how you would answer that general question.
Yeah, this is a question I get at every meeting, which is how do I deal with in-laws or as my mother-in-law says, outlaws. So it's in the world of estate planning, unless you're related by blood, you have no right to anyone's assets or inheritance. So if I don't say to my son's wife gets nothing, it passes to my son, or if my son is deceased, it passes to my grandchildren. So it's the quick and easy answer is, unless you say it, it doesn't happen. The only time a in-law gets it is if it passes to my son and then my son dies. Now my daughter-in-law is an heir to my son, but my daughter-in-law is not an heir to me.
Perfect. And we have 1 minute left, so we'll go ahead and ask the second question, which is, how do we go about funding our trust? So Jeff or Stephen, if either one of you want to take a minute or two to give an overview of that, the answer to that question.
I'll take a stab at that, right? So gifting and funding a trust, it's not that hard, right? So we talked about the thresholds or the exemptions that the government gives you, right? So the IRS creates the problem, but they also give you the solution. So earlier, Stephen spoke about the estate tax threshold, right? Which is your lifetime exclusion, the amount of money you can transfer into a trust. So if you have enough wealth, right, where you can just simply write a $15 million check, right, to a trust, good for you, right? So that's one of the easiest ways to do it, is using your lifetime exemption. But There are a lot of ways to do it, right? Depending on the type of technique you can that you use, you can leverage certain discounts, specifically around minority ownership interest, and there's things like cuprates that you can also leverage discounts. And the second way, right, and I think which is really the most common and easiest way to get started with gifting is your annual exclusion gifts, right? So currently, $19,000 per year per person. So to piggyback on what Stephen said, right, you can give it to anyone you want, including your favorite state attorney and financial planner. So I add myself to that list, right, because there's no limit to how many people you can give that $19,000 per year to. Now, obviously, you wouldn't do that. So anyone who's interested in establishing a gifting strategy, right, the proper way to do it is meet with Stephen, get your documents drafted, right? For estate tax purposes, the trust that you gift to has to be an irrevocable trust, right? It cannot be a revocable trust. A lot of times people think, yeah, I have a trust and I put everything in there already. Well, no. A revocable trust serves a much different purpose than an irrevocable trust. So anytime that you do gifting for estate tax purposes, asset protection, you want to make sure you're using the right type of trust. In this case, it would be an irrevocable one. So, Stephen, I don't know if you want to add anything else to that, but I think that was kind of my best stab at that.
I'll just add one thing, which I think you just started to touch upon, and then I have a question. You have to be aware of where you're putting it, because if you're putting it into an irrevocable trust, such as a Medicaid asset protection trust, it's gone. So, I never say fund everything into a Medicaid asset protection trust because it's going to leave you destitute. That money cannot come out to your benefit, and you have to do a cash flow analysis. The question I'm going to ask Matthew, since he's the one who asked me questions, is do you know the difference between a tax code and a Rottweiler?
Wasn't expecting that question, Stephen. I do not know the difference.
A Rottweiler lets go when you die.
That's funny.
That's a good one. I might have to steal that from you. But gentlemen, thank you so much for the I will. I'll cite you as a reference to the joke when I use it. But gentlemen, thank you very much for the answers to those questions. Folks, we want to be respectful of everybody's time. We appreciate everyone spending the last hour. We hope this was impactful. Once again, if there's any appetite to schedule a consultation, you could do that directly off of the QR codes you see on the screen, or of course, you can reach out to us directly. You see our contact information there. We hope to have an opportunity to speak with each of you in the future. And once again, we thank you for your time and have a wonderful evening.
Thank you.